Picture this. You're in a crisis. A full-blown legal battle is on the horizon, but you know the courts move slow, and every single second is costing you. So what do you do when you need to stop the damage, like right now?
Imagine you wake up one morning and find out your business partner is just draining the company bank accounts. By the time you get a court date, all that money and maybe your entire company could be completely gone.
Or maybe it's this. A competitor is just days away from launching a brand new product, and it's built entirely on your stolen ideas, your trade secrets. Once that hits the market, the cat's out of the bag. The damage is done. You can't get that advantage back.
Or hey, let's get even more real. There are actual bulldozers at your property line, engines running, ready to tear down some ancient landmark or piece of land you cherish. You just don't have weeks to wait for a hearing. In moments like these, you don't need a lawsuit that takes months. You need an emergency brake. So, what if I told you there's a legal pause button you could hit to freeze everything right in its tracks?
Well, you're in luck, because that's exactly what we're talking about today. This legal emergency button is real, and it's called a preliminary injunction. And honestly, it is one of the most powerful, immediate tools in the entire legal system.
So what is it really? A preliminary injunction is an order from a judge that happens way before the main case is ever decided. It's all about preserving the status quo, hitting pause to keep things just as they were right before the conflict blew up. It can either stop someone cold from doing something, or in some special cases, actually force them to do something.
Okay, so this legal pause button, it actually comes in two different flavors. And it's really, really important to know the difference between telling someone to stop and telling them to start. So let's break that down. First up, you've got the prohibitory injunction. This is your classic stop order. It commands someone to just refrain from doing something. Stop the bulldozers. This is the one you see most often. But then you have the mandatory injunction, the start order. This one is way more rare and a lot harder to get. It actually forces someone to do something, like telling a company to reinstate an employee they just fired. Courts are much more careful with this one because it's not just freezing the situation, it's actively changing it.
So this all sounds incredibly powerful, doesn't it? It is. And because of that, courts don't just hand these out like candy. You can't just walk in and get one because you're mad. You have to prove 4 very specific things. Think of them like 4 keys you need to unlock this super powerful remedy. All right, here they are. First, you need a clear and existing legal right, not something you might have in the future, but a right you have right now. Second, you have to prove that someone is either violating that right or is about to. Third, and this is the big one, the one that's often the hardest to prove, you have to show you will suffer irreparable injury. And finally, number 4, you must convince the court that there is no other reasonable, fast, and adequate legal option. Basically, you have to prove this is a true emergency, and this is the only thing that can prevent a serious injustice. Let's drill down on that phrase, irreparable injury. What does it actually mean? Well, it means the damage is so bad that you just can't fix it with money later. If your competitor leaks your secret formula, you can't unleak it. If that beautiful old tree gets cut down, no amount of cash can bring it back. That's the reason a court has to jump in immediately, because if they wait, any final judgment they make will be totally worthless. Okay, let's say you did it. You proved all 4 points. The judge is nodding along, convinced. You're about to get that emergency stop order. But hold on, there's one more really important step. The court's going to need a kind of security deposit from you. And that makes total sense, doesn't it? If a court is going to drop this powerful hammer based on just a preliminary hearing, there has to be some kind of protection for the other side. What happens if, months down the road, it turns out you were wrong? This protection is called the injunction bond. The court will make you post a bond, which is basically a pile of money you put up. That money sits there as a security deposit to cover any damages the other party suffers because of the injunction. If it turns out you shouldn't have gotten it in the first place. It's the court's way of making sure you don't use this thing recklessly. So, the bond is posted, the injunction is official, the bulldozers go quiet. Your partner is locked out of the bank accounts. Everything is on pause. But you have to remember, this is not the end of the fight. Far from it. This is really just the beginning. And here's the absolute key to all of this. Getting an injunction isn't a final victory. It doesn't mean you've won the case or that the other person was wrong. All it means is that the court has hit pause to stop a disaster from happening while the real legal process can finally play out. So, the big takeaway here is that a preliminary injunction is an extraordinary remedy saved for extraordinary situations. It's for those truly urgent, high stakes moments where waiting for the system to work would mean justice arrives way too late.
And there you have it, the power of the law's emergency button. Hey, if this explainer helped you get your head around this really powerful tool, do me a favor and hit that subscribe button for more. And now I want to hear from you. Have you ever been in a crisis where a legal pause button would have changed everything? Tell us your story in the comments.